Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have a couple updates from the judge this morning in the Blake Lively versus Justin Baldoni case. The parties were arguing on whether or not the deposition transcript should be stricken from the record. It wasn't available publicly, it was filed under seal, so nobody could see what was in it. But Wayfarer did file her entire deposition transcript as an exhibit. We'll take a look at the judge's reasoning for that in a second, but the court did unseal an interesting portion of the letter that had that deposition transcript attached to it. It was previously redacted, and it was the part of Blake Lively's deposition where she explained her only knowledge of any ongoing smear campaign, which, as we know, is a weird fantasy shadow thing that she's concocted in her mind. So here it is. Upon questioning by Friedman at her recent deposition, Lively admitted that the only ongoing smear campaign about which she has personal knowledge involves a retaliatory lawsuit and the press that you, Friedman, have done and the statements that you have made about me and my character. If that's true, as she said under oath, then why the fuck did she subpoena 107 content creators or social media users? I wasn't there when Brian Friedman did his press run, and Brian Friedman certainly didn't use my maxed out credit card. Why the fuck does she want my credit card number to make any statements about Blake Lively's character? Nor was I present when he did so. So why does she want my geolocation data going back over a year? As I said before, the more stuff comes out, the more you're going to see transparently how these subpoenas were used as a tool to chill free speech and nothing else. This was never an evidence gathering process. It targeted people who didn't start talking about the case until after the lawsuits were filed, so they knew that none of us would be able to really give any information that would be useful to their claims of a smear campaign before the lawsuits were filed. And apparently, the only knowledge of a smear campaign from after when the lawsuits were filed, the ongoing smear campaign, was this bullshit. And this has nothing to do with us. Now, a couple of things from Judge Liman. Here is why he decided to strike the deposition transcript. The letter broadly asserts there is no evidence the Wayfarer parties, Brian Friedman or his firm, have participated in a smear campaign against Lively. For support, the letter quotes one fragment of one sentence from Lively's deposition. In the deposition, Lively testifies that she believes that the Wayfarer parties have retaliated against her for reporting harassment by engaging in an ongoing smear campaign, but she appropriately refuses to reveal information disclosed to her in confidence by her counsel. And no surprise she would say that. I mean, we've seen them try to use the attorney's eyes only provision and stuff like that to make it sound like there's damning information about people hidden behind these seals, only for them to have their bluff called, and then they end up embarrassed and looking even more dishonest than before. Lively now moves under FRCP 12F and the court's inherent power to strike the attachment on the grounds that there is no conceivable legal purpose to file the whole transcript. The court agrees that the inclusion of the entire deposition transcript served no proper purpose and accordingly grants the motion to strike. The Wayfarer party's attachment of the entire nearly 300-page deposition, after citing only 2 pages of it in the letter, served no proper litigation purpose and instead appears to have been intended to burden Lively, and as a result the court, and invite public speculation and scandal. The Wayfarer parties have not even attempted to argue that the entire deposition was relevant, nor could they. The conclusion is inescapable that the Wayfarer parties filed gratuitous amounts of irrelevant pages so that, if Lively moved for continued sealing of the irrelevant pages, the Wayfarer parties could then use Lively's response for their own public relations purposes. The court has not only the power, but also the responsibility to step in. The Wayfarer parties' actions follow a pattern of using filings on the docket as an opportunity to litigate this case in the press rather than in court. It is not routine for parties to attach an entire confidential deposition transcript when citing only limited portions of that transcript, involving only a few lines of text in order to put the other side in the court to the burden of justifying continued sealing. Now, look, this is probably an unpopular opinion, but I kind of agree that they didn't need to attach the entire deposition transcript. But that being said, both sides are playing it aggressive with their court filings. Only one of them is substantially less successful in the PR and public opinion space with those strategies than the other, primarily because they're using the docket to attack people who speak unfavorably of their client. So while I understand the strike, I was also on the receiving end of a strategic filing for public relations purposes quite recently by Blake's side, so I know that both sides are doing this. We have one more update here from the judge, and it's regarding some recent letters that were filed mostly by Perez Hilton, I believe. So let's take a look at what he had to say about that. Recently, a number of filings in this case have included intemperate language and personal attacks against parties, their counsel, and the court. All individuals filing documents in this case, whether represented or not, are advised that they shall not in any submission to this court use language that is disrespectful of the parties, their counsel, or the court, This includes, but is not limited to, using demeaning nicknames for parties or their counsel, or accusing the court of being in words or in substance biased, criminal, or corrupt. In other words, parties addressing the court in writing should use the same respectful language that they would use in person in open court. Well, I think that probably is the language that Perez would use in person in open court. And if he disagrees with that, he'll probably tell you himself. So, for avoidance of all doubt, this order does not prevent any party or non-party from vigorously arguing on behalf of their clients or when appearing pro se on behalf of themselves, or from asserting publicly that a decision of this court or any other court was wrongly decided, or that an argument promoted by a party or non-party is incorrect. Failure to comply with this order, for example, use of such language in any court submission, may subject the infringing party to risk of contempt. All right, so I guess he didn't like some of the language that was being used. As we know, Perez was very direct in his recent letters, but there is an order now by the judge, so he's going to have to decide, how to proceed. I think a lot of us were affected by the social media subpoenas, and then Perez was actually subpoenaed directly. So everybody's kind of handling it in their own way. I'm not really here to comment on that in one way or another. I mean, I just read the court documents and I handle my own situation as I see fit. That's all I can really do. So, all right. Thanks, everybody. That's all I got for now. I'll see you all soon.